Did Thomas Crapper really invent the toilet? How did Soviet-era famines give us Tony the Tiger? How did Sigmund Freud's nephew use bananas to start a 36-year civil war? You can learn all about these and hundreds of stories in my new book, Facts That Aren't True. Link in the description. I'm of the opinion that the government and the laws and the judiciary system, at least in the United States, functions primarily in a utilitarian sense, not really a moral or any kind of religious sense. Now, yes, all kinds of things that we regard as being morally wrong are illegal, but that's because if they were legal, then people would be subjected to misery and they would revolt. For example, why limit people's freedom to be able to drive as fast as they want? Because it puts other people at grave risk of being killed, which is, yes, something we regard as being basically morally wrong, but we also regard the government restricting your freedom to be morally wrong. So we are restricting a freedom at the expense, or rather for the proliferation, maximization of other people's freedoms. Now, in order to maintain our rules-based system that has this practical, pragmatic, utilitarian structure undergirding it, we have to invent rules, which means we have to make them up. What is the actual distinction between a 17-year-old the day before their 18th birthday and a legal adult? None. Except for the number of times the Earth has gone around the sun since they were born. Now, from time to time, some of these rules get put in front of the court to test the merits of them. This video is about that, but it's also sometimes about the times when courts seemed to break with reality. For example, in the late 1800s, there was a case of Nix versus Hedden. The short of it is there was a tariff on vegetables, and that included tomatoes. And so one party was suing the other saying, hey, I shouldn't have to pay a tariff on these tomatoes because they're a fruit. They're excluded. The entire case seemed to really just hinge on the definition. They just brought in dictionaries to say, look, a tomato is a fruit. However, the courts, well, it's not that they didn't disagree. Here's what they said. Botanically speaking, tomatoes are the fruit of a vine, just as are cucumbers, squashes, beans, and peas. But in the common language of the people, whether sellers or consumers of provisions, all these are vegetables which are grown in kitchen gardens and which, whether eaten cooked or raw, are, like potatoes, carrots, parsnips, turnips, beets, cauliflower, cabbage, celery, and lettuce, usually served at dinner time with or after the soup, fish, or meats, which constitute the principal part of the repast. No idea what that word is. And not, like fruits, generally as desserts. So because you eat tomatoes during dinner time and you cook them, they're not a fruit. This seems really strange to appeal to the common language. There's the really famous example of Bill Clinton, and his legal defense was, well, what does the word is mean in this statement? Clinton had lied under testimony, committed perjury, when it was revealed that he lied about his affair with Monica Lewinsky. What Bill Clinton specifically said was, there is nothing going on between us. And so his defense hinged on what the word is means in that sentence. Does is mean something currently going on or something that happened in the past? If it means something that's currently going on, then he didn't commit perjury. Now, Clinton was found guilty, so I guess that's a bad example for me to use. But the way product labels and commercials and all kinds of things spell out this incredibly moronic language that says, this product is not really a type of blank or something like that. The only reason they're doing that, I would presume, is because they have been sued over it in the past. The justices went on to say, the attempt to class tomatoes as fruit is not unlike a recent attempt to class beans as seeds, of which Mr. Justice Bradley said, We do not see why they should be classified as seeds any more than walnuts should be so classified. Both are seeds in the language of botany or natural history, but not in commerce. Now, what's funny about that is there's a strict botanical definition of what a nut is. A nut is a simple dry fruit. It develops from a single ovary. It has a hard, stony pericarp. It doesn't naturally open, and it only has one seed. What's hilarious is, according to this, walnuts, almonds, pecans, peanuts, Brazil nuts, and cashews, none of those botanically are nuts, but those are the only thing you find in a can of mixed nuts. Juice drinks have to be labeled with how much juice they contain. It's usually like, 0% to 5%. What if we had to do that for mixed nuts? What if it said mixed nuts and then on bottom said contains no nuts? Can you imagine how nuts that would be? Yeah, this next one isn't very fun. The case was Buck versus Bell in 1927, and it was around the issue of forced sterilization. The state of Virginia had a law that said forced sterilization of people in institutions for those who are diagnosed with hereditary mental illnesses or whatever was constitutional, and they said it didn't violate the 14th Amendment. Ultimately, the Supreme Court agreed. There was a woman named Carrie Buck. She was diagnosed with feeble-mindedness, whatever the hell that's supposed to be, and she was in a state institution, and the state wanted to sterilize her so she couldn't have any children. She challenged those laws, saying that it violated her right to due process and equal protection. Ultimately, the majority in the Supreme Court said that the law did have enough legal safeguards and there were procedures in place to protect a patient's rights, so it didn't violate due process. Maybe their thinking was because she was mentally incompetent, she didn't have the ability to advocate for herself, so due process, like the government was basically serving as her guardianship. I'm not sure, but what was argued was that the law can focus on the practical utility or what is immediately possible. So the government can't go around just rounding people up they regard as being feeble-mindedness. They can only allow it to happen for people who have been institutionalized. Kind of sounds like a little bit of a contradiction, but this was their view on the utilitarian aspect of it. Oliver Wendell Holmes was the justice who wrote the majority opinion, and his conclusion of it was rather disturbing. He basically, in the end, says, quote, 3 generations of imbeciles are enough. This is obviously disturbing because what if the government starts to decide that nobody with a below average IQ is allowed to have the same rights or allowed to have children as anybody else? After all, they're below average. Luckily, we know today that eugenics is complete pseudoscience. The next case was Dober versus Merrill Dow Pharmaceuticals. Now, this case was about what sorts of standards should courts use to decide whether or not scientific expert testimony is reliable and admissible in court. This case occurred in 1993. We have to go back 70 years before that. The precedent had been set 70 years before in 1923 in a case known as Fry versus the United States. What happened, and this is actually kind of funny, the defense wanted to use the results from a lie detector test to support a defendant's innocence. The court rejected this. The court said that lie detector technology, which I had no idea was around in the 1920s, but they said that wasn't widely accepted in the scientific community. So the precedent was essentially something like consensus. Now, the problem is scientific consensus, new research and data, that can take a long time to develop. So we can be making decisions based on wrong information for decades leading up to the necessary research and public opinion in the scientific opinion at least to change. So back to Dober versus Merrill Dow Pharmaceuticals. The Dobers were arguing that an anti-nausea drug had caused birth defects. However, the current consensus behind this drug was that it was safe and effective. What ended up happening, because this was a controversy, there seemed to be some scientific data that supported that that the Dobers had a case, but the consensus data was not behind them. So the Supreme Court threw out the old Fry standard. We now have what's called the Dober standard because of this, and it's still what is used today. The standard laid out is whether or not the theory can be tested, whether or not it's been peer-reviewed or published, what is the known or potential error rate, are there standards controlling the method, and is the theory generally accepted in the scientific community? So the Dobers won at the Supreme Court on the concept of the legal standard. From that point on, the Supreme Court kicked the case back down to the lower courts, and ultimately, the Dobers never won their case. The next case, and this is just one of the funniest things ever. I don't know how to actually say these names. I'm going to say Selig versus Fabian. The short of it is, Fabian was a promoter of this Baconian theory, which it relied on doing all this weird encryption or decoding of supposedly encrypted messages, rather. And Fabian had come to the conclusion that Francis Bacon had written all of William Shakespeare's plays and sonnets. Now, Selig was releasing a film for the anniversary of 300 years since Shakespeare's either birth or death, I don't remember. And so Selig sued Fabian. The judge ruled in favor of Fabian, who's the guy promoting the theory that Francis Bacon actually wrote all of Shakespeare's plays. So Selig lost, and Selig had to pay $5,000 to Fabian, the equivalent of over $100,000 today. The reason he had to pay that was because Fabian was trying to release a book where he pushed all this Baconian stuff. Selig was suing to prevent that book from coming out because it would damage the release of his movie. I don't know what precedent he was trying to use. I don't think you could hardly call this libel or slander, because it's not like the guy's slandering you. It's against William Shakespeare. This is a long time ago. This is in 1916, and that ruling came out in March, but as early as May that same year, two other judges said, "What the hell is this?" And they dismissed the case. Oh, and it turns out that the judge and Fabian were childhood friends. All right, the next one. I remember when this was going on. This is an extremely charged time, but Monsanto, there were two different cases, Monsanto versus Hardeman and Johnson versus Monsanto. So this is famously over the issue of glyphosate causing cancer. Ultimately, Monsanto has been ordered to pay out over $300 million, but this is going back to the Dober standard. Ultimately, the Environmental Protection Agency, the World Health Organization, many other bodies, no conclusive link to glyphosate and cancer has been found. I hate billionaire monopoly conglomerates. And environmental justice has a very storied history in this country of being something incredibly important. But this is a little bit uncomfortable. Anecdotes aren't data, and I get that it sucks to hear that. It kind of sucks to say that when what's going on is what somebody personally suffered greatly from. But it just doesn't look like the evidentiary standard was met for this. Now, in all fairness, there has been an organization, the International Agency for Research on Cancer, which classified glyphosate as probably carcinogenic to humans, Group 2A. That may sound definitely convincing, but I mean, do you think that bacon, sausages, and deli meats cause cancer? Because those are in Group 1. All that does is establish a causal link. And also, to be fair, Monsanto, there were internal documents released that showed they really, really aggressively tried to target this and make it sound like not a big deal, even though they didn't know with certainty to what degree it is dangerous or not. The next case is Harris versus Florida. Now, this is about dog sniffing. Now, because of your constitutional protections surrounding privacy, you can, in theory, be caught with something illegally, but if the procedures were not followed out correctly, that ended up with you getting caught with the substance or whatever, then your case can be thrown out because your privacy was violated. The only episode of All in the Family that I can actually remember the plot for is one where Archie has tear gas in his taxi to protect himself. I don't remember why, but a cop is looking around in Archie's taxi and finds that tear gas. Now, it's not legal to carry that. Archie ends up going to court, and yep, he's in possession of a weapon that is illegal, and he's absolutely about to go to jail. And then at the very end of the episode, the judge asks the police officer, "Wait, did you have a warrant or probable cause?" And the police officer says no, and the judge throws out the case. Now, the dog sniffing thing is weird. Apparently, dog sniffs have an error rate of up to 80%. However, dog sniffing as grounds for probable cause is treated as infallible. So dog could be sniffing around and they find something on your person, but with a success rate of 20%, I mean, couldn't flipping a coin almost give better results? This has ultimately been withheld, by the way. But after thinking about this, I think it's actually even stranger than that. Let's say that dog sniffing is 100% reliable. I still think you could make a case it violates the Fourth Amendment, because doesn't this amount to being searched without consent? What if all of a sudden we had the technology to have X-ray glasses? So then it would be fine for the police to walk around everywhere with their X-ray glasses on and peer inside of everybody's clothes and look for contraband. I don't know the exact legal language or stipulations around this, but I know there's this concept of it has to be in plain sight. I don't believe we should ban drug-sniffing dogs, but this is bordering on the edge of something that's kind of uncomfortable. And the final one is the State of Louisiana Science Education Act. Now, this isn't actually a court decision, but what this did was it gave teachers the freedom to use supplemental materials after presenting the required material. And this is so that people can bring up their own personal religious ideas to try to undermine science. This act would fail the Lemming test. It would absolutely fail the Dober standard. But that's why I do what I do. Hopefully you thought that was a little bit fun and a little bit informational, and you'll see me tomorrow.